So they've been really good.
You survived the building, basically. I'm sorry. Oh, no. Someone that told them to go you. I got a rough few minutes. Good. And I was losing.
I'll take care of the word.
Hey, guys. One person that told me that they made large. Yeah. I had a buddy, but
Reading
the
free news and war. You love reading, don't you?
Yeah,
That's not work. I mean, I'm pretty good at countries like that.
Right.
Sometimes it's questions, you know, it's stuff that I'm used to for. I really can't. Since that Bible is with me. It's important when you're young to try to memorize as much. Because it's in there.
But it's not a budget meeting. It's not a budget meeting. Yeah. Just say no. That's what's gonna be on my plaque. Just say no. New motto.
This is a moment of prayer. Based.
They call it a moment of silence now.
Oh, yeah,
Come
moments.
a long ways, but we went the wrong way.
All right. It is time. It's 9 o'clock. I'm gonna call this meeting to order. I've asked Commissioner Curtis to open us in meeting for the prayer.
Heavenly Father, we just come before you today and humble ourselves, Lord, and think about our nation, Lord, being 250 years old, Lord, and just the great work that you've done in it in the past and through it, God. And we just thank you. We're grateful to be able to live here, God. The freedoms that we are given, God, by you. And the founders of our nation seeing that, Lord, and putting that in the Declaration of Independence and putting it in our Bill of Rights, God, we're grateful for that today, and of, for, and by the people still exists, Lord. So we just want to give you praise and honor today. Help us to humble ourselves and seek your wisdom, think about things, slow down, try to hear your voice in all this. Because our problems and things that we face every day, they're God-sized problems. And we ask for your help today. Ask for your blessing. In Jesus' name we pray. Amen.
Amen. All right, pledge to American flag. I pledge allegiance
to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pledge to the Texas flag. Honor
Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you. You may have a seat. All right, I'll call this meeting to order. We have a quorum present. We are missing Commissioner Barton today. And I will ask y'all to silence your cell phones if you have one on you, please. And item number 2, general announcements. Do we have any general announcements? Mr. Barton, would you give us a summary of the events celebrating our 250th?
Barton.
Yes, I'm sorry.
That's all right. Yes, full weekend of activities coming up here in Canton. And we have representatives here from the city that can help me fill in the blanks in case I miss something. But starts tomorrow on the first Monday grounds. It's going to be an Air Force band performing on the first Monday grounds. I believe they got 3 concerts scheduled: 11:30, 12:30, and 1:30 tomorrow. Friday, I believe there's a concert on the west side of First Monday, Friday evening. And then Saturday is the big day of activities downtown. Starts with the kids bicycle decorating contest at 9:30, followed by the kids watermelon eating contest at 10, and the parade at 10:30. And then later in the day, there's going to be a car show and live music on the west side of the First Monday grounds at 5 o'clock, followed by the city fireworks show at dark.
Busy day. All
Come
right.
one, come all.
Any other public comments? Or are there any other announcements? Did we have anybody sign up for public comment? Okay, all right. So we will now move into item number 4, consider and take appropriate action to approve acceptance of an engagement letter with the Sledge Law Group, PLLC for the joint legal services of the creation of a regional groundwater conservation district and authorizing the county judge to sign all related documents. I want to give, Brian, are you here? Can you hear us?
I hear you. Do you hear me?
Yes, sir. Okay, before you start, I want to give everybody a kind of a history of what we've done. And in the past year, we have been researching groundwater conservation districts. We've had several workshops on it, and we've had discussions about it. And sometime earlier in this year, Cole Hefner, state representative, got together with 13 counties, judges 13 counties, and they started discussing having creating a groundwater district for the counties that didn't have it in East Texas. And after their initial meeting, they realized that 3 other counties qualified to be in it that weren't in the district, and that was Van Zandt and Rains and Hopkins, I believe. And so they've been added. So there's a total of 16 counties being considered for this groundwater district. Groundwater district is a way to help regulate the water wells and the use of water. And in that regard, it's the only provision that the state legislature has allowed. This county itself cannot do any regulation, but a groundwater district can. But it's a process that takes some time and requires the legislature to actually approve the district to be created. And what has happened is after these meetings is the counties, each of the counties is making a decision whether or not to become part of this groundwater district and to participate in the legal work that needs to be done in order to get it passed in the next legislative session. So with that, I will now turn it over to Brian Sledge, who is with the firm that is looking at doing the legal work for us to get us started.
Well, good morning. Are y'all able to see me?
Yes, sir.
Am I able to share my screen?
Yes, sir.
All right, I'm going to do that.
As long as our IT department gives you permission.
Oh yeah, I just sent them a request.
All right, they just allowed it.
Okay. Y'all seeing that map?
Yes, sir. We see it.
Okay. Well, good morning. I think this map is illustrative of the issue. I'll give just a little basic framework because groundwater law doesn't come naturally to people, and it didn't come naturally to me. When I got out of law school 32 years ago, my first job was at the House of Representatives on the Natural Resources Committee that does the water legislation on the House side in the legislature. And I was there for 4 years and learned all about groundwater conservation districts. And then I went to the State Water Development Board as director of research for 2 years and learned a little more. And then 1999, I went into private practice. Um, and I practice mostly water law, and I have an active practice on water law and water policy issues at the Capitol. But when the legislature goes home, I'm general counsel for a lot of different water districts, special counsel for counties and cities, and a few others. Lots of TCQ type matters, lots of groundwater conservation district, lots of water supply matters. So the law in Texas, well, I got a PowerPoint here I didn't intend to use, but I'm gonna go through it. Just a couple of things. Well, I'll leave it there for now. The law on groundwater in Texas, as you know, surface water of the lakes and streams, those are owned by the state of Texas, held in trust by the people for the people of Texas. TCQ administers those, but when it comes to water in the ground that you access through water wells, the law has been the rule of capture since 1904, when over in the Denison area up on the Red River, a man named East was living peacefully when the railroad came through town and drew a big well to support its operations, and Mr. East's well went dry. And Mr. East sued the railroad and went up all the way to the Supreme Court, and the Supreme Court decided to adopt the English rule of capture, which is to say that the railroad, ultimately the bottom line is the railroad could suck Mr. East well dry without liability. That you have an absolute right as an owner of land to try to drill down and get the water out of the ground under your property. And if that happens to impact your neighbor, so be it. They decided that causation was too mysterious and occult, they said, on what happens to water under the ground to let cases like that be in the courts. So in 1917, the legislature, or the people of Texas adopted the Conservation Amendment to the Texas Constitution, which placed both the authority and the duty on the legislature to regulate natural resources. And groundwater still went unregulated until 1949. The legislature finally came up with its plan for how it was going to regulate groundwater resources. And that plan was basically a local control decision to if you have problems managing groundwater, or you're having groundwater let water levels drop in your aquifer and in your water wells in your part of the state, you can create a local groundwater conservation district, and you can regulate that resource. So the very first one was up here in the Lubbock area. This High Plains Water District was the very first one, and now we have 100 of them across the state. You can see though in Northeast Texas that there's a big gap, a big region there on the state. There are other areas of the state you'll see on this map that, like the central part underneath Wichita Falls, that don't have a district, or out west of Midland, Odessa, but they also don't have much water. And when we look at this map here, if I can make my screen share, hold on, technical difficulties. One second. I don't know if I can switch slides while I'm sharing. Hold on a second.
You need to stop sharing one screen and then share a new one.
Yeah, okay. Sorry. I'm good at law, but not technical things. I'm just gonna have to close this program and start over. One second.
So while he's doing that, I want to also explain that we intend, today's agenda item is engaging in this agreement with them. And we have a resolution about joining groundwater district that we are going to present in the future court meeting. And we will have a workshop at that time to allow public input and discussion before we sign the resolution. So that I don't know if it'll be on the 15th or if it'll be a meeting in August, but I just want to give you that input.
Okay, I think I got it. You see two maps there, two maps of Texas there?
Yes, sir.
Okay. So these are the major and minor aquifers in Texas. And you can see up in your area of the state, you've got this the map on the left are the major aquifers. You've got the major aquifer, this red one that stretches down through Van Zandt County from up near Texarkana, the Carrizo-Wilcox, which is probably the most prolific aquifer in the state. And you can see on the map on the right side of the screen, there's a bunch. These is the minor aquifers. Again, they can be pretty important sources of water to folks where they are. They're just not as large and prolific as the majors, but y'all got this little stretch of green coming down through there, the Nakatoch, and I don't know if y'all are able to tap into the Woodbine, the light blue one up there, or not. It's probably starting to get pretty salty by the time it gets to you. But what I wanted to demonstrate from this map is that underneath Wichita Falls, this Seymour, the cross timber aquifers, if you make a 5 gallon per minute well there, that's nothing. I mean, that's something special. There's no major aquifers over there. And so the only real big area of the state, going back to this map, that has major groundwater resources but doesn't have a groundwater conservation district is this giant block of counties in Northeast Texas. And so I'm sure many folks are familiar with what's happening just to your south in Henderson County and in Houston County and Cherokee County. There are folks looking to do major water projects in those counties to suck that water out and send it off to customers elsewhere, perhaps in the DFW Metroplex, perhaps down the river to Houston. Not quite sure on that, but there are multiple what we call groundwater marketers in the state. looking for areas that don't have groundwater management, don't have a groundwater conservation district to manage the resource. And it, you know, from I've been doing this for a long time. From where I sit, it just leaves a bullseye on you for folks to target you for. I mean, all the low hanging fruit on surface water resources have dried up. They've been taken. There's only a handful of surface water resources that could even potentially be developed left in the state. Folks started looking to groundwater projects about 25 years ago. Boone Pickens did a big groundwater project up in the Panhandle. Clady Williams did a big project down in Southeast Texas. There's a couple of big projects in Central Texas, Bastrop County, Bryan College Station area, where they're going to be bringing water from the Carrizo Wilcox, your same aquifer in that area, and bringing it over to Central Texas and the I-35 corridor. And no surprise, if you sit and think about it, they've ultimately they've come over to you and said, you know, hey, look at this big chunk of the Carrizo in Northeast Texas, and we have some minor aquifers in the same area. There's water to be taken, and so the only option under the law, as we said, besides rule of capture and letting them take it, is you can put a groundwater district in place that can manage that resource. And so groundwater conservation, well, let me show you this. The state, you can create a groundwater conservation district one of three ways. A landowner petition process to the TCEQ, a TCEQ initiative, or the first bullet here. Most of them are created by the legislature, and having done that several times, I'll tell you that's by far the preferred route, because either one of the TCEQ options, the TCEQ can't custom tailor a groundwater district to your local needs. They have a one size fits all, call a tax election, elected precincts. You can't exempt anything. You can't put any special provisions in. So the vast majority of the 100 districts that have been created through the legislative process. What do groundwater conservation districts do? Well, when they get up and running, they've got a job to start collecting some data and science on water levels, on the aquifers, on what water levels have been doing over time, which way they've been trending, coming up with numeric groundwater models where you can model what this amount of pumping at this areas of the aquifer would do to the aquifer. How would it impact shallow household wells if somebody came in with a big project? They do a lot of science and data collection. And when you see that, you figure out that, hey, without a groundwater conservation district, there's not a whole lot of that going on until we create a district. They participate in regional planning. I think I've got a map here. Yeah, one second. There. The state's divided up into 16 groundwater management areas by the Texas Water Development Board. Y'all are sitting over in groundwater management area 11, and you can tell from looking at, I've got the major aquifer map sitting next to the groundwater management area map. You can see that those are pretty much drawn along aquifer boundaries. And so each district within one of these GMAs, each district within GMA 11 sends a representative to meet with the other districts. Water doesn't stop flowing at the county line. What happens in one county or one district can impact what happens in another. So there's a coordinated effort. It's kind of like a cog. It's a coordinated effort for planning among the groundwater districts that overlie a common aquifer to set goals for the future of the aquifer. They're called desired future conditions. What do we desire our aquifer conditions to be in 50 years? And they redo those planning goals every 5 years. And so it may be, well, we don't want water levels to drop more than 50 feet from where they are in 2026 by 2076. But they get to adopt those, and then each of the individual districts go back and they manage the resource to achieve those goals. So, yeah, I just kind of went over there. Once every 5 years, the groundwater districts and the GMA develop DFCs. Back up here. After a groundwater district gets some science in place, they've got to adopt a management plan. Those are approved by the Water Development Board, but it's basically a study setting forth what the nature of the groundwater resources and aquifers are in your area and coming up with management goals and for those aquifers, kind of like a state agency. There's performance metrics. Well, we'd like to get 10 monitoring wells drilled in the next year. They set up, and the board of directors of the district can set goals for the staff to achieve. We want to put on, 50 elementary school water conservation education programs over the next year. And then at the end of the year, at the annual report, you look and see if they got 50 or 60 or 30. But anyway, they come up with management plans, including what they want the aquifer to look like in the future, how they want it to be managed, and then they adopt rules to implement those management plans. So they adopt a permitting system. So large wells, most small wells like household type, livestock wells, things like that are exempt from the permitting system. But bigger wells, municipal wells, industry wells, big commercial wells, any one of your public water supply wells, those are going to have to come in and be subject to the permitting system. Permitting system to try to achieve those long-term goals that were set for the aquifer. And you can do that by, when you set long-term goals for the aquifer, again, if we, for example, said, we don't want water levels to fall on average more than 50 feet over the next 50 years, you can put that through a computer groundwater model that is approved by the Water Development Board. And they tell you, okay, well, if you want water levels to be there in 50 years, here's how much on average you can let be pumped out of the ground each year between now and 50 years from now. And so you're using your permitting system to try to achieve that and not let folks come in and grab a big old chunk of water from a small tract of land like some of these marketers are trying to do. Finally here, bigger groundwater districts do it better. The biggest problem we see with a lot of the little districts is they just don't have the finances to do the job right. They can't get the science work done, they hire the engineers, the hydrogeologists to do the science, lawyers to help them with permitting and contested hearings and things like that. It doesn't take twice as much money to run a 2-county district than it does a 1-county district. There's economies of scale there. One general manager, one office, one set of rules development, one management plan, one hydrogeologist, one auditor. All the things y'all deal with in local government, they too have to deal with. You have more comprehensive management. The bigger it is, the more area of the aquifer that you cover, the more you can make sure that everybody over the aquifer in your region is on the same page and under the same set of playing by the same playbook. And they're just a lot more cost effective. So that's why when we go back over here and look at these counties and then this big block of unprotected counties, and then we look at the big regional aquifer over here, when Judge, you mentioned that Representative Hefner had called a meeting of 13 counties to start this discussion with. How did it expand to include 3 additional counties, y'all and Range and Hopkins? It was because I showed them after that meeting, I said, hey, look, we've got 3 counties that will be located out here on the western side of the Carrizo-Wilcox Aquifer, Hopkins, Range, and Van Zandt. They really ought to be included in your bunch. That was my suggestion to them, so that because, you'll have, that'll be a lot more economical for them to join in with the rest of them, and you'll have more comprehensive management of the aquifer. So that's how y'all got invited after the first meeting to the table, was because it makes sense to do so. Groundwater districts have always been funded by one of two ways. Either property taxes, which prior to about the late 80s and 90s, that was the way that most districts were funded. After property taxes became a four-letter word, they started financing them through pumpage fees. Those same large well owners that would be subject to the permitting system have to pay pumpage fees based on the amount of water that they pump or that they're authorized by permit to pump. And virtually, with just one or two exceptions, I think just one exception, everything in since the year 2000 has all been financed by production fees. And that's where the district gets its finances. When you talk about production fee-based financing for groundwater districts, it's important to have bigger regional districts, because one or two or three little counties charging pumping fees to finance the district, the pumping fees would have to be so exorbitant that, people wouldn't tolerate them. But especially, if you don't have just a huge amount of pumpage in those counties. Again, the small mom and pop type wells, they're exempt from paying. So, so you get districts that, they just couldn't raise a budget. But when you put all these counties together, like Representative Hefner's proposing to do, 16 counties, then everybody can, within a reasonable fee rate, finance the whole district. What else? Let me get through here. That's kind of how people don't understand how a aquifer looks. This is a cross section that includes y'all's area of the state. Aquifers are kind of like a big club sandwich. And I like to think of them, and it doesn't come naturally to people, so I'll just say it. If you had a big bathtub full of sand or full of gravel, you could pour a 5-gallon bucket of water in there and it would hold it. And that's what aquifers are. Over geologic time, layers of the earth have been laid down, and where you have layers of high sand or high gravel or a mixture of those two, there's water mixed in there. So the Queen City here, the Carrizo, the Simsboro, and the Midway are the water-bearing formations here, and then they're oftentimes separated by layers of clay or shale that don't allow much water to move. So when a well driller drills down, he's trying to hit, you can see here, the light blue color is freshwater sand. He's trying to hit those freshwater sand layers in this prolific aquifer. Simsboro here, as you can see, nice light blue. That's the one that everybody wants to hit up there in y'all's neck of the woods. Very prolific aquifer. But you can also see that, it stretches out across, this thing's about as wide as a county and a half, this slide is, and anybody drilling down on the county next to you is going to go tap into the same region. And it's, all that's under artesian pressure. When you have a well that goes down into the Simsboro, because of the artesian pressure inside the aquifer, it pushes water way back up the well bore, which makes it, and it drives water to the well bore, which is what makes it a good source of water supply. And when you have these big projects coming in from, exporters, folks wanting to export water, which, is the biggest problem. It reduces that pressure, and people's water levels fall down to where they may not be able to economically pump water anymore. That's kind of how that looks. We went through that. Governed by a board of directors, elected or appointed. I note here that most large groundwater districts have directors that are appointed by the elected county commissioners of the counties that comprise the district. And one reason for that is, elections, if you tried to had to draw election precincts in a 16 county district, I mean, you could use up a quarter of the district's entire budget. And just it becomes cost prohibitive in drawing giant districts like that. Just like river authorities, Sabine River Authority or Trinity River Authority, they have boards that are appointed by the governor because doing elections in big, large areas like that is almost just not feasible. Oh, I went back. Uh, again, primarily funded through, I just covered that, property taxes or production fees. Went through that. Again, here's kind of how the management happens by the district. They gather the science, they set the desired future conditions on a regional basis with the other groundwater districts. They incorporated those into their management plan, and then they adopt rules to implement their management plans.
Mr. Sledge,
Yes, sir.
perhaps we could go on to some questions. I have a few questions that
Okay.
I think you're searching around there, and perhaps we can go to these.
Al, I'm happy to stop talking.
Uh, are any counties already agreed to engage your services related to this?
Yeah, I think we've already got 6 or 7 that have signed up.
Do you have an estimation on the fees that each county will be and how those will be apportioned?
They're apportioned equally by county. It's a flat fee. If all 16 counties join, it's $1,218.75 a month plus cost.
Okay, and is that a cap or is that just your estimation?
No, that's it.
Okay.
Yeah,
Okay.
that's it. But that's divided by 16 counties. It's $19,500 a month for the next 12 months, which takes you through the end of the legislative session and the governor's veto period.
And what will your firm be putting together all of the information related to get this through the legislature to hopefully get it passed?
Yeah, what the agreement calls for is that each county appoints one representative, the county judge or somebody else. I think most of them are appointing the county judges to sit on a committee to go through and work through these issues and prepare the legislation. Obviously, we've got to, work with our legislative delegations in the House and the Senate and carry them alongside us as we go. But we will draft a bill to create the district and try to get everybody on board with how it's going to be created. Starting
So
off. Go ahead.
And again, this is Cliff Williams. I'm Commissioner of Precinct 2 currently. The impact in the county is on commercial wells and private wells are exempt. Is that statutorily exempt, or is the exemption on private wells just something that the groundwater district will agree to in advance?
Well, there are some that are statutorily exempt, but statutorily, any domestic and livestock well on a tract of land 10 acres or larger is exempt by statute. In practice, the districts will, and it depends on the district and the local circumstances on how they do it. But in practice, they're going to exempt all domestic and livestock wells, smaller than a certain size, but because you just don't have the resources to deal with them all. You just try to, you've got to exempt everything that's out there already when you get created. And you try to deal with, like we have, for example, in Parker County and Weatherford, just due west of Tarrant County and Fort Worth, next door. They're drilling the developers have turned, because there's no cheap water available, the developers over there have turned into a pattern of everybody has their own private well and their own private septic. So they're chopping up a 1,000-acre ranch, take out some acreage for the roads and putting in 800 tracts of land with everybody's got their own well and septic. That's not sustainable out there. Those people are going to invest in a home where they don't have water in 30 years. And so the groundwater district doesn't want to permit those wells because, again, trying to deal with homeowners and enforce permits across thousands of homes, you just can't do it. You don't, there's not enough money to hire enough staff to do that. So you deal with them by spacing them out. You know, any new well has to be so far from the property line and so far from a new well. Or kind of like y'all septic regulations, a groundwater district can adopt a minimum tract size for a new well. Anybody that wants to drill a well in that county has to have at least 2 acres. And the developers adjust, you know, okay, now they're carving them up into 2 acre tracts. But you almost invariably deal with the household wells in your rules only through requiring them to be spaced so much apart. And you got to do things like, well, I had a place that was only 1 acre in the country and I had it and I was planning to retire out there. Well, okay, lots that were platted prior to the adoption of the rule, you can still get a water well. But they don't, I don't have any districts. I've represented at one time or another 22 of the 100 groundwater districts in the state, either as general counsel or special counsel. And I don't think I've ever had one that permitted a household well.
But in let's say in 5 years when, AI takes over the world, what's it going to take for this groundwater conservation district to begin including private wells in their rules?
I'm sorry, I don't understand the question.
So right now, private wells are exempt. What would it take for private wells to not be exempt? Would it just be the board saying, no, we found a way that we can go out and look at each and every one of these individual wells? What would it take for them to then be included and it not just be commercial?
Well, first I want to make sure we're talking about you're talking about household domestic wells.
Yeah, I'm talking about every water well that enters into the Carrizo Wilcox.
Okay, well,
could they just make a vote? Could this groundwater conservation district just vote? No, we're going to do private wells as well.
When we say do them, make them have a permit,
Regulate them or monitor them in any way.
They regulate them. I mean, they don't require a permit, but they regulate them. Some do. I mean, not all do, but some that do regulate them by well spacing requirements, by making them be so far from a property line or from a new well.
Well, let me explain to you the concern, and then you tell me how it doesn't happen.
Okay.
Today we talk about these are for commercial wells.
Yep.
And people who own existing private water wells for their cattle or for their home are saying, well, what would it take for them for them, either the legislature or the groundwater conservation district or whoever it might be, to say and begin implementing rules that would begin to monitor private wells and then would begin to limit or tax each individual private water well out there? Would it just simply be an election of this board, or would there have to be a state law, a change to the Constitution of the United States or the state of Texas? What would it take in order for the groundwater conservation district to begin to impact private water wells?
Well, okay. That was a lot. Let me try to peel it off one layer at a time here. They can regulate private water wells as it is. They can, except for the statutory exemption, as for any domestic livestock poultry watering well on 10 acres or larger, they can't regulate at all, period.
Okay, that's the answer. That's the answer right there. Is if you've got if you have more than 10 acres and you have a water well, then
Yep,
they can put limitations or restrictions or anything else on a well that is on more than 10 acres.
they cannot touch those at all. The Texas Farm Bureau has protected that provision, and it's in the Texas Southwestern Cattle Raisers have protected that provision, uh, and nobody's messed with it. And as long as I've been part of this stuff,
So if you have less than 10 acres and you have a private water well on there, they can now regulate those.
they can.
And the groundwater conservation district, from a statutory perspective, depending on what their rules are, and their rules can always change, right now can regulate or impact less than 10. They just don't do it because it's not economically feasible to do so.
They can regulate anything that is when it comes to private landowner wells. We're not talking about commercial wells or industrial wells or public
That's
water system wells. They can regulate anything that's on smaller than 10 acres. And
But like you say, they just can't. We can't afford to do that at this point because there's not enough revenue for them to go out and look at all of the myriad thousands of private water wells that have been drilled in the state of Texas.
there's and there's no need to go look at them. Nobody wants to go look at them. These folks don't want to go out on people's property and get shot. There's just much easier ways to protect homeowners and their private wells than by trying to if you had to require everybody in Van Zandt County to come in and do something that was approved by the commissioner's court, every single household, you understand that that's not something you could take as a commissioner's court. And so you don't, you've got to deal with the issues you've got to deal with, and you deal with them on a more holistic basis. And so what districts do when it comes to private wells is just set up the rules for development on if you want to, just like y'all do with septic, or I don't know if you do it with septic, but most counties do with septic. If you want your own septic system, you got to have 1 acre land. It's the same way that districts do it. If you already had a septic before the county adopted the regulations, you're not going out there to tell people that they have to, tear their home down. Groundwater districts aren't going to tell all the current well owners that they got to stop doing what they want, but they try to deal with and there's many areas of the state where individual household wells, they just aren't a problem. That's not the problem that they need to deal with. But if they do deal with them, they deal with them by setting up the rules. Okay, starting today, you developers, here's the rules. And they'll work with their counties and say, counties, FYI, if y'all allow plats to be carved up into less than 1 acre or whatever they come up with, just know that those folks aren't going to be able to drill a water well under our rules for plats that y'all approve going forward.
So
And that's how they deal with them because,
if we start down this road of joining this water district, how long does it take to get that established?
get which part established?
The water district itself. Like how far are we from this point today to that water district being established?
Well, if we're successful, we're going to start working as soon as we get all the commissioners' courts finished with doing this. We'll start working through the fall on agreeing on, what's going to be in the legislation, how the board is going to be governed, and I'll submit to you, it'll be a fee-based, not a tax-based district. We'll have appointees from the commissioners' courts to sit on the board. That'll be the board of directors. Anyway, we'll get a bill ready to file. The legislature comes to town in January. We'll get a bill filed. And hopefully, if we're successful, we'll get that bill approved by both the House and the Senate and off to the governor's office and signed by him. And that's likely to happen, if it happens, before the legislature leaves town by the 1st of June. And then it's off to the governor's office. He's got 20 days to deal with it after it gets to his desk. And so it would be next summer, if we not next, this time next summer, July the 1st, we will know for sure whether we have a district or we don't have a district. And then that district will have to, like I said, the first thing they're going to have to do is adopt a management plan. They will, just because I've been through this with so many of them, I'll tell you how it plays out. They'll have to adopt temporary rules, which will be aimed at the large well owners, the big public water system, industrial type wells, commercial wells. And they'll say, okay, folks, you got to start. Everybody has until, and I'll just use some random dates here, but it'll be something like this. Everybody has until January the 1 of 2028. All you big wells to get a meter. Of course, all the public water supply wells are metered anyway. Most of the wells are metered, but and starting on January 1, 2028, you have to start recording your pumpage, and you report that to the district quarterly or semi-annually or monthly or whatever they come up with, and you'll pay a fee rate of 30 cents per 1,000 gallons that you pump. That's due to the district after that. So they'll do that for a couple of years to start getting a revenue stream and getting science in place, so that they can start working on, figuring out where the issues are, what are the threats to the aquifer, how do we want to move forward, and then ultimately, a couple of years after that, they'll probably adopt their first permitting system.
The commercial, you said that the groundwater conservation district will drill test wells. Is that early in the process?
They don't, no, they won't have any money to drill a test well. No,
That was my point.
Yeah, they're not in the well drilling business. They do, the better districts around the state do sometimes drill their own monitoring wells if they need one. But one thing they try to find is how can we come up with a network of monitoring wells that cover the different aquifers in different areas of the district, so that we can start to piece together better information on what's happening with the aquifer, what it looks like. So typically they can find a number of wells that are no longer in use from folks, and they can enter into an agreement to use those for monitoring. And they'll send somebody out with a tape measure to monitor water levels once a year or something like that. Or now it's a lot easier to put telemetry equipment down in the well that sends you the readings. But over time, you start developing hydrographs. Okay, well, here's this well right here, and here's what it looked like in 2026 and 2027. And so you can say, oh, well, the aquifer's declining about 6 inches a year or something. And then you can project that out. Okay, well, going back to what I said earlier, when you set your aquifer goals, the desired future conditions, we say we don't want it to be more than a 50-foot decline in aquifer levels, because we're also, they can go and look at the well logs from the old water well drillers board. They can figure out what the depth of different wells are in the area. They can figure out where the pumps are set, and I don't know how deep y'all's wells are out there, but you can see, man, well, if aquifer levels fall this far, these people on the western side of Van Zandt County, their wells are going to start going dry, in about 2040, 2050. And so, but until you got the science and the monitoring wells to do that, but it costs a lot of money to drill a well. So they typically will find old abandoned wells, or a lot of the public water suppliers will allow them to come do measurements once a year on their static water levels to try to piece that information together.
So one last question, and I appreciate your spending the time. If there are data centers that are planned in these 16 counties, those data centers would be subject to the groundwater conservation district and the water usage and all the rest of this business?
They would.
And what can you, to a groundwater conservation district, I should know this, but I don't. Since it's a governmental or quasi-governmental agency, are they subject to freedom of information requests for information?
They're subject to everything the county commissioners court's subject to. They are a governmental entity. They are a political subdivision of the state of Texas. They're subject to the Open Meetings Act, Public Information Act, ethics requirements, everything.
I don't have anything further.
Can I judge, that question?
I got a question.
Okay, go ahead.
What is the definition of a commercial or industrial well? Is it
Well, I don't know that there's a single definition for them, but it's not a household well.
okay, is there a certain amount of water pumped out on a daily, monthly basis?
It's it would be a non-agricultural, non-household, non-livestock well, and it might be a municipal well, it might be an industrial well, steel plant, power plant. It might be oil and gas well, flooding operations for secondary recovery, something like that. Those are, it might be, a factory. I don't know.
So what, once we implement this on the permitting, are all wells that are considered commercial, industrial required then to get a permit and start paying a pumping fee?
Yes, sir.
Okay.
I mean, the district could exempt, in theory, they could exempt wells that are smaller than, 10 gallons a minute. I've got Bob's Beer Barn out here on County Road 233, and, technically he's got a 10-gallon per minute well. Technically, he's a public water supplier, a transient public water system. They can exempt things like that.
If it's 30 cents per 1,000, he's not going to have much of a bill.
Yeah, that's not.
So what is the method of measuring the amount of water pumped?
Meters.
Put a meter on it.
Meters. Okay.
Yeah, they'll typically require them to have a non-resettable totalizing meter, and to keep a meter log monthly and to send that in with their pumpage reports, which again vary from district to district, whether they do it monthly, quarterly. A lot of the public water systems like to ask the groundwater districts to do it monthly because they're doing monthly records anyway. But some of them do it quarterly, some of them do it semi-annually, some of them do it annually. Pay. Some of them, after they get permits issued, they'll just say, here's the amount, 30 cents per 1,000. You've got a permit for 10 million gallons. Send you $30 in by January the 30th, and you're good for the year. But that kind of differs from district to district. I'll tell you, back to the data center question. I don't know if y'all have gotten any of that business over there yet, but I'll promise you it's coming. I can't. My phone's ringing off the wall across the state with areas that don't have a groundwater district where data centers are coming and they can't do anything about it. Two, some of my little sleepier groundwater districts that all they ever had to deal with was a few local water supply corporations, and they've never had any issues. The aquifer never had any issues, but they've got power plants and data centers coming in now, and they're scrambling to get their books in order, and getting ready, because you know, all the same people that show up at Commissioner's Court to fight data centers and similar such, you know, when it comes time for the water permits to support them, they're showing up at the groundwater conservation district, and they have and citizens have the right to protest those permits, right? It's just like a TCQ permit. You show up and you say, man, we don't think they're entitled to that much water. That's gonna really impact my property next door. And they can request a contested case hearing in the groundwater conservation districts, just like TCQ or the Public Utility Commission. They use the State Office of Administrative Hearings to conduct those trials and have an administrative law judge prepare findings of fact and conclusions of law for their consideration. And then just like when it comes back to the TCQ commissioners to make a final decision on a permit, those groundwater conservation district directors get to make the final decision on the permit. And, but boy, I'm telling you, everybody's hopping. We just had about a 10-hour legislative hearing last week. Cody Harris from Palestine and his House Natural Resources Committee on data centers. There's hundreds of them coming. So, and I'll tell you, just because I also have gotten many calls from data centers wanting to hire a water lawyer, they're looking for areas that don't have a groundwater district. That's the sweet spot.
All right, are there any other questions from the Commissioner's Court? All right, Brian, appreciate your time.
Yeah, absolutely.
And
Thank y'all.
you bet. So, item number 4, consider take appropriate action approving acceptance of an engagement letter with the Sledge Law Group LLC for the joint legal services in the creation of a regional groundwater conservation district and authorize county judge to sign all related documents. Is there a motion to allow us to engage in acceptance engagement letter?
So moved.
Is there a second?
Second.
All right, any further discussion? All those in favor say aye.
Aye.
Opposed, like sign. Motion passes. Almost ready to take a break. Item number 5, discuss consider appointment of Angela Bell Williams to the Van Zandt County Historical Commission. Is back from the Historical Commission. Oh, there's a few people back there. So her name has been submitted, and is there a motion to approve her to join the Historical Commission? I assume that you will abstain from making a motion.
I'll make that motion.
Okay,
Second.
Mr. Phillips will make that motion. Mr. Curtis will the second. All those in favor say aye. Opposed, like sign.
Abstain.
Abstain. I vote for.
Oh, okay.
Okay, so it passes. All right, item number 6. Thank you very much. Discuss, consider selecting a scoring and evaluation committee for RFQ 2601 for the architectural services of Van Zandt County Courthouse Annex. We discussed this at the last meeting, and we gave out the list, but it was decided, it was recommended that we have an outside community person on that scoring committee. What the scoring committee does is, and we have received the request for qualifications from architects to say, you know, what their qualifications are to do the architectural work. And so the scoring committee will go through and evaluate it, and then each scoring person will score it, and then the results will be tabulated by the auditor's office, and then the decision will be made by the Commissioner's Court. And we have for that scoring committee from the auditor's office, Lisa Hutcherson; from the Commissioner's Court, Bobby Phillips; from our public buildings department, Chris Burnett; from the public, Brian Cummings; from our IT department, Scott Slayton; and our treasurer, Kenny Edwards. Those are the 6 members of the scoring committee.
On that committee, Mitch, did you decide that you don't want to? Okay.
I have somebody I want to put on it. Are we doing that today?
We're doing it right now.
I have a guy in my precinct that wanted to be on it. His name's Gary Roberts.
Gary Roberts. Roberts
Robert,
with the S. Okay,
Mr. Gary Roberts.
and his qualifications are,
Probably as good as anybody's. I mean, he was,
You know, in business, I guess he worked for the.
all right. So, those are the 7, scores. Is there a motion to approve?
Is that all that we're gonna put on it?
Yes.
Mhm.
You know, really, you don't want it to be about 5 or 6, but,
Okay.
we'll go 7.
I think an odd number is better than an even number. So I think that's great. I'd make the motion to approve that list of 7.
All right. Is there a second?
Second.
Any further discussion? All those in favor say aye.
Aye.
All those opposed, like sign. Motion passes. Item number 7, discuss and consider the approval of the selection of a grievance committee for Texas Local Government Code Section 152-015. Grievance committee. Let me read this verbatim. Chapter 152 of the Local Government Code creates a salary grievance process for elected county and precinct officials to challenge their salaries, expenses, and allowances as set out in the proposed budget. So an elected or county or precinct officer who disagrees with the salary, personnel expenses provided in the proposed budget may request a hearing before a salary grievance committee before the budget's final approval. The 9-member salary grievance committee generally consists of the county judge, the sheriff, the tax assessor, collector, the treasurer, the county clerk, the district clerk, the county attorney, or criminal district attorney, and the number of members of the public necessary to provide 9 voting members. The county chair or the county judge is the chair of the committee, but is not entitled to vote. As an alternative, the Commissioners Court may vote to have the committee consist of 9 public members, which is also chaired by the county judge. And that is what we're here to do today. Do we want to appoint the committee or of the public officials, or do we want to use the 9 public members, which, as we have done in the past, is composed of the members who have served, citizens who have served on the grand jury in the last year. And those names are all put in a bucket and are drawn out to serve as the on the grievance committee. And then once the salaries are published, which they're not going to be, our recommendations will not be approved until mid-August. And then once those are published and put out there, then elected officials have the opportunity to submit a grievance. And then if we have agreements, then we'll have engage this committee. And if we don't have agreements, we don't have to have it.
How is a grand jury picked? How do they pick the grand jury?
I don't have that information.
It's a will that Karen, the district clerk actually has, so it's randomly done, it's not, nothing else.
Is it out of registered voters? Okay,
So they're just asked if they will serve on it?
yes, typically a grand jury serves for a year and they meet once a month. And
It's service.
it's sort
Two different.
okay. I stand corrected, they serve for 6 months.
But they're random. They're random.
Yeah, I prefer the grand jury approach because I think that when you have some of the elected officials serving as the grievance committee, you have interpersonal issues or preferences, prejudices that you don't have when it's a nonpartisan grand jury group. That would be my preference, that we do it that way. And last year, I don't think we had any grievance submitted. I don't know, but so that's my preference.
All right, would you like to make that motion?
I do make that motion that the grievance committee be made up of those participants of the grand jury who elect to participate in this process.
All right, motion made. Is there a second?
I'll second
Okay, any further discussion? Looked like you were fixing to say.
I was just curious if Bobby had any thoughts on it.
I was gonna say, in the past, we've done it with the from the grand jury selection, and I think that's great. I feel the same as Cliff does, that I feel like sometimes that there could be a problem with elected officials mainly being on it because of the us knowing each other, friends, and, you know, I feel like it's more of a fair situation.
Non-biased.
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 Hopefully.
Unbiased.
Yes.
The reason I asked that about how the grand jury is picked is because I had a constituent tell me that the district judge handpicks the grand jury. And but that's what they thought. I just want to try to get to the closest we can get to the average taxpayer being able to make decisions on their government.
Well, I think that's it right
And
there.
I think that's what we have right here.
Right, I think by doing it this way, that if you want the average taxpayers to be the ones to do it, then this is the way to do it.
That's right.
Okay.
That's good.
Any further discussion? All those in favor say aye.
Uh,
Pose like sign. Motion passes. Item number 8, discuss, consider a 6-month lease agreement and payment concerning a belly dump trailer from Brazos Trailers for precinct 3.
Yes, Judge, this is mine, and this is just a yearly deal that I guess we have to have it approved. I have one trailer left. I had 3. They kind of went up on my prices, and so I cut back to 1.
Okay.
And I'm asking that I guess I'm making a motion that we accept this.
All right, motion's been made. Is there a second?
How much is it, Bobby?
It's $250 a month on this.
$2.50 is a good price.
That's what I'm saying.
I wish.
I second the motion.
All right, motion is made and second. Is there any further discussion? If not, all those in favor say aye.
Aye.
Opposed, like sign, motion passes. Item number 9, discuss and consider authorizing county judge to sign the Rural Ambulance Service Grant Program Award IA-0000003160 for the grant amount of $350,000 to be used toward the purchase of an ambulance. I don't know, if it was December? Was it December that we actually voted to apply for this grant? And the application period was in December, January. And we just received notification in the last 2 weeks that we have been awarded this grant. And
I'd like to mention that this is 102% Keegan Caldwell's job. I mean, she found it, she researched it, she planned it, she put together the information, and she made sure we got all of our applications in on time. So in the event that all the commissioners agree to accept this grant, or even if they don't, I sure do appreciate all the work you do. So I would second
it's her fault.
Yes, it is her fault that we're going to have, we'll have and I would mention that last year when we were talking about this, our current service provider indicated that they would staff this vehicle and they would be happy to, because it helps, it helps them. This is Van Zandt County's, and they're going to be using it on Van Zandt County roads, and they're going to be using it on Van Zandt County people. And so we appreciate them, and we really appreciate Keegan Caldwell for all her work, keeping track and making sure we're all moving in the same direction.
If on that note, I don't think Keegan gets enough recognition for what she does do for all of us, because she has 4 commissioners demanding commissioners that she keeps up with, and on my behalf, I would like to thank her for what she does for us.
Very much. So, and thank you, Keegan. Not to change the subject. Okay. We will need to come up with an agreement. The intent is that the ambulance would be provided to Christus to finish out and to use. But we will still need to come up with an local agreement with them about the use of it. And
it has to be in our precinct.
Don't fight about that.
Is it a four-wheel drive?
A military grade, right? All right, is Commissioner Williams, you made the motion.
I make the motion to approve the grant.
Okay, is there a second?
I second that.
All right, is there any further discussion?
Also second what, Commissioner Williams said about Keegan.
Okay. All those in favor say aye.
Aye.
Pose like sign, motion passes. Item number 10, discuss, consider authorizing the services of Trot Communications from May 26th through December 26th for radio communications consulting up to $55,000 to be charged to ARPA interest funds account 476 and we have with us on the Zoom Barry Black, who is our representative, and I just want to say because of L3 Harris's because of delays in the process of getting the final acceptance of the radio system project, we are need to continue his services, especially for the final testing where we do the coverage testing and all of the compliance issues that they need to do. That's where Barry has been instrumental in keeping L3 Harris to the contract terms. So do you have anything to mention to say, Barry?
No, I mean, Judge, that's exactly correct. I think the delays and a lot of those have been associated with personnel issues with L3 Harris making big changes at mid-management levels and at project manager levels that have, really extended this project way beyond where it should be. And probably the other big issue is, of course, the coverage, with the coverage issues that came up over in the Van area. And then also in some of the schools that are requiring the installation of additional equipment at L3 Harris's cost, that has slowed things down as well. So you're correct. The testing, there is a lot of coverage testing that still has to be done once everything's kind of finalized on the equipment out in the field. And then there's some additional acceptance testing on some various system features that weren't ready to be tested 9 or 10 months ago that we just been holding off to try to be efficient when we do that testing. So once those are done, and then of course all the as-built documentation and all the project closeout documents are real important. This project can get wrapped up and final acceptance payment can be made to the vendor.
Okay, and is our intention that this all be completed by December 31st? Because that's when the ARPA funds need to be spent and in that regard. So is there a motion to approve this additional amount of 55? It's budgeted. I'm positive we won't hit 55,000 and if we get things under control. So is there a motion to approve this?
And this is coming 100% out of the ARPA.
The interest
funds
that we have accrued over the last 3 years.
It seems like the never-ending story, doesn't it?
Yeah.
But it's at some point it will come to an end, right?
Yes.
Yes.
So what you're saying is, you said December 31st. We're hoping to have 100% finished up, done with.
We better have 100% done, but we're not gonna take it in the next year.
Okay.
We cannot, we will not pay L3 Harris. We will not have final acceptance until they have met the requirements of the coverage requirements, which that requires the 6th site to be constructed and up and running. And once that's done, then we can do the coverage testing.
Is it possible to have that up and running in the 6 months that we're saying?
Yes, it is quite possible.
Okay.
We're got all of the planning stuff done, and now we're just waiting on L3 Harris to move forward with it.
To start the construction.
Right, yeah,
So do they have to build another tower?
we have leased the tower.
Okay. That's right.
Leased
That's
the
right. I'm
tower.
sorry. I remember that. Yeah.
And that tower.
So it is possible.
Yes.
Yeah.
Yes.
So is there a motion?
I'll make that motion.
Is there a second?
Second.
Any further discussion? All those in favor say aye. Opposed, like sign. Motion passes. All right. Item number 11. This is a workshop to discuss and consider the interlocal agreement with the city of Canton for road repairs and maintenance. And I put a copy of that agreement on your out there for you to review. And so anybody who wants to take the lead on this? I know we have signed an interlocal agreement with the city of Van. And Canton is the next one. The one thing that is of concern, well, it is different from the one in Van is that the city of Canton affects all 4 precincts.
Mhm. Well, as far as precinct 2 is concerned, I am a lame duck, so I'm not approving or agreeing to anything under these circumstances. And I can't tell you that I would agree to if I had been elected. The funds that precinct 2 pays, I mean, we don't get any sales tax money, but precinct 2 non-municipal residents certainly go in and spend a fair amount of money in Canton and in the other cities. And I wouldn't even consider that to ask the city. And so I can't in good conscience believe that the city of Canton would, and this is probably the reason why I'm a lame duck, would ask us for road money or work inside the city. Wouldn't do it. Can't do it. And since I am a lame duck, I'll just fall back on that and I won't say anything.
Well, I have a lot to say about it. I looked at the original, I guess what Commissioner Melton, as he proposed, I guess he was the one that proposed the 10-cent tax for road and bridge. And if you look at those documents, it was specifically for county roads. I mean, it's hard to read it any other way. That's how it was proposed to the public, and they knew what they were voting on. And then we opened the door right before the last election to the city of Van, and it cross-contaminates everything. Like it's a bad, I don't know if that's a proper use of verbiage there, but I've already been called into some of this. I have 4 cities in my precinct, so.
And I have only Canton.
And like it's an open-ended book. There's no rhyme or reason to how we're going to spend the money. It was just voted on. We're going to spend some of our budget money on there because they're paying taxes. I'm like Cliff, the people that live in the rural areas, when they come to Grant Saline, they're not coming there to sightsee. They've seen everything Grant Saline has. They come there to buy groceries and gasoline and hardware store. And so they're paying, a fair amount of tax money inside the city limits. But I didn't vote for it when it came across the first time. And I'm not voting for this one.
I would add to that I did, and I did for a philosophical reason. I believe that when you put something in your budget, if you want to buy a piece of machinery to make bubble gum, if you've got it in your budget, I wouldn't buy it. But I am not going to tell you how to run your precinct. And so when Commissioner Barton said, "Hey, I want to give some, I want to pave all of the streets of Van with gold," I'm gonna say, you go right ahead. If that's what you want to do, you go right ahead and do it. But for precinct 2, I'm not.
I'm okay with your reasoning on that. I think this is going to sound insulting, but I think a lot of times we're very impulsive as a court. We make decisions pretty quickly on things that we really probably should slow down and think about how that's going to affect everything. How do you feel, Bobby? Like
I can't go with it because I enjoy living. And in my precinct, if I start doing city streets, y'all have me hung out there somewhere, and I'm not ready for that.
That's a little more
I'm-
extreme than my.
I'm working very hard to turn our county roads around, and it's taking every penny I can get a hold of to do it. And I just, I can't do it. You know, now, I don't mind helping out. I basically only have Wheels Point as far as a big city, you know. And I don't mind helping out on the stuff that I can do. But there's no way I can come in and redo a city street.
So Mr. Commissioner Barton's not here, so I'm gonna argue with him. He said that, you know, the city's always fighting with the county and the county's fighting with the city. I've never had any trouble as long as I work for the county, and I work for the county now 14, 15 years. We worked in the city of, actually 20 years ago, I bladed out a whole subdivision with their material and our blade. The city of Wills Point, the city of Edgewood, the city of Fruitvale. We haven't had to do a whole lot for the city of Grand Saline. They asked me the other day, I was called into the city of Grand Saline, and this was the conversation. They said, you knew we'd be calling. And I said, and y'all knew I didn't vote for it. And I was told, and that's not going to go well for you. And that's what I talk about. That's what I mean when I say cross-contamination of budgets. Because, you know, in general elections, cities across the country carry the vote. And if a city's liberal, then a lot of times you have a president that's liberal, right? So big voter blocks can controlling a commissioner's thought process is not a good thing. That's just how I feel about it. Does that make sense to you?
Yeah.
Because out in the county, you know, they may not be represented as well if the city can say, hey, we give $280,000 a year. Well, on a $1.3 million budget, $280,000 in one city is a whole lot of money. And we didn't determine anything when we opened our budget up to the city. We're just going to build a road for you. They give $280,000 a year. Well, if that's the premise on how we make that decision, then they should get their $280,000. It's open-ended. There's no parameters of how much we're going to spend of our budget in the city. So I can't be for something like that. And if I'd like to tell you how I really feel about it, but I'm not going to.
Well, on my reading, and Tony will correct me if I'm wrong, this interlocal agreement basically explains, sets the parameters if we're going to work together. There's no financial commitment involved in this agreement unless it's agreed to by the commissioner in the city. Is that kind of a good summary?
That's correct. It's basically the framework for the agreement. It's not an agreement stating that you will do work. It sets up the parameters, the terms and conditions, if you were to agree to work or to do a road in the city.
Right. See, and I'm aware of Commissioner Melton in his time working with the city on Cherry Creek Road, because it was a disaster. Not because it was because the material that they got was horribly bad, and that he was very frustrated. I mean, I can tell you that because, you know, and as all do, you know, you take pride in the work you do, but if you get bad material, you end up spending a whole bunch more time redoing the work that you got. And so, but that was an agreement that he had with the city to do that. And that's kind of what I see this being right here, is that the commissioner, you know, commissioners can, when the city asks for help, and, you know, if you look on the map over here, you'll see, you know, a lot of county roads that go right into the, can't see it here.
Well, this says materials on responsibility of the county. So yes,
This wouldn't be necessary if he had done it before. This must be something different. So in this, I'm following your line of thought there. I mean, if Commissioner Melton did something on Cherry Creek, it's already in place. There's no reason for a new resolution. There's no reason for a new MOU. We know that there's something different.
Did he
MOU.
buy the material?
Okay, the interlocal agreements are only good for a year.
Did he buy the material? Have we, you know, I talked to two other commissioners that have been here, and I went outside because I have a few friends I actually have a few friends that are commissioners outside the city, outside the county. And they said, no, we never let the city in our budget. We do work for the city with our equipment and we provide the manpower, but we do not get in our budgets. And, you know,
Well, the interlocal agreements that we've been doing over the past few years is basically, yes, we do the work for the cities, but they pay for the materials.
right.
There's nothing in this agreement that says that can't be made, that can't be part of the agreement, because you have to have an agreement.
It says we are responsible for labor, equipment, supervision, materials.
Okay, but it also says that no agreement, the city and the county have to come to an agreement on what the
Traffic control. We're responsible for that. Maintain records of actual costs. I mean, there's a whole lot of things that we're responsible for. Here that, like, I can tell you, I don't know how much Bobby spends on traffic control. But if you go to the MUTCD or anything that the state, we all fall under that. Like, that could be a pretty significant cost. I mean, it's just open-ended, like, it's just, there's no parameters of, I mean, this looks good on paper, but it wasn't written by a person that's out there on the street doing it.
all right,
It just opened the door that before we walk through it, we need to really think about.
And then they even get to inspect it and approve it after we're through with it. And if it don't pass their thoughts, there we are. I mean, that's just,
Like, I've got 4 cities. If a project takes 3 to 4 weeks, that's 16 weeks out of a year that I've got to work in a city. If I decide to treat them all equally.
well, I think that back to what Cliff said about Brandon agreeing, I think that even we should have our privilege, I guess, to, I don't know that that's the correct word, to decide if we can or can't help. And I'm gonna treat them all the same. If I've got the money, you know, can afford to help them out in a situation where I feel needed, I'm gonna help them.
You have 2 cities.
Yeah, I have part of Canton, and then I have part of Canton, all of Wills Point, and I classify Marble Springs, you know, as in there too. You know, and so, you know, I mean, I want to treat them all fairly. And
I don't disagree with that until you get into the money aspect of it.
exactly, that's where I was going.
okay, and that's where this interlocal agreement right here on the item of scope of services, item C. Project-specific approval, each project undertaken pursuant to this agreement must be approved in advance by both parties through a written project authorization or work order executed by both representatives. Each work order shall identify the project location, define the scope of the work, establish a not to exceed amount, specify the cost sharing allocation, and include an estimated schedule, confirm availability of budget funds. No work shall commence and the county will have no obligation to perform services until a fully executed work order is in place.
Tony, this is a question for you. If I get a work order from them, if we go through with this and I get a work order from them and I refuse it, or
Well,
do I have that ability?
you shouldn't get a work order from them until they have communicated with you
Exactly.
and worked out the
Right.
details of
But-
what's gonna be.
But the
part
way
of
it sounds here, that they can just produce the work order to me and then,
It has to be agreed by both parties. So in other words, they submit a work order to you, And you say, you know, you do it, budget is allow it, I don't have the materials, I don't have the work. The
But-
employees to do it.
I guess what I'm getting at is what does, if any of us refuse it, then where do we go from there? What happens after that? Is there,
The work doesn't get done.
if it doesn't get done, then do they have,
No, all,
recourse?
this is a framework. How everything's already been agreed to in advance, so
Yeah.
to speak. And then the work orders where you're gonna actually agree to the cost, the scope, everything that you're.
What's wrong with our basic agreements with the other versus a 6 page?
Okay, we no longer have any interlocal agreements in effect because they're only good for 1 year.
So is this
So
gonna be
the ones that
valid?
we have signed with Edgewood, Fruitvale and whatnot are not no longer valid until
When did you get 'em
they're
done?
approved again.
If you don't do this and they come to you and want your help with something, then you bring it before the court. And y'all vote on it, just do it, you know, need this in order to do
What?
it.
Once you have the interlocal agreement, then it's just on that commissioner.
No, if you don't, you still bring it to the court. Do you need this in order to work with them? Is it a necessity? Is that a legal question? I'm not sure.
If there's work being done for another entity, yes, an interlocal agreement needs to be signed that allows for that to occur.
So you would not be able to do that without this in place. Is that what you're saying?
No, you would come to the court, I would think, and do, you know, a bullet agreement.
On an individual basis.
Able to. Just every year. Do an interlocal agreement with all the cities or whatever. And that way you have it there, so every year it comes up, you know, same.
You approve them at the same time.
And that way, if something comes up, you're able to, whether it's your equipment, maybe not about the material, but equipment on, stuff like that.
I think we should renew them all at the same time for one thing, and
I agree.
and then and the court needs to do it because the leadership in the cities changes, like they don't know what's available to them, so the court needs to be the one in control of that, but. I just think when we get in our budgets, there's just a big enigma, it's a lot of questions. And I don't know the answers to them. You know, do you do it on a percentage of how many miles each city has? Like Grants Lane has 99 miles, Van has 30 something miles. I don't know, I don't know where it's at.
So what you're doing is you're looking at the framework of this and all the terms of our thing. Everything's different. So basically what you're doing, if you bring back the work scope, is saying, okay, everything's already been agreed to other than the price. And then at that point, that's when you talk about price to negotiate that. And the time frame, excuse me, how long it's gonna take. And that's, so everything else has already been taken care of. That framework is already, if it's agreed to, that framework's in place, all you're worried about now is the materials, maybe the cost and the time frame. So that's what you're looking at, in the future for the work order.
Right. It's basically nothing different than our old MOUs. But it's more specific about getting the details of what's going to be done. How to get the details of what's to be done before we move forward.
You know, if you look at it that way, I think it's leaving out a critical component. A critical component of this is that the cities are saying our citizens pay 10 cents on property tax, which is the road and bridge tax. And the people of Van Zandt County voted in favor of this in 2015. And that language in there is specific. It says that it is to be applied to county roads and bridges, not roads and bridges in the county. In order to take a portion of the 10 cents and you know, again, this is there's some legal parsing here. If it said roads and bridges within the county, then we could use a portion of that 10 cents on any road or bridge that's within Van Zandt County. But that's not the way that was written. The way that the specific proposal was written was county roads and bridges. So if one of these roads is a municipal road, you can't use the 10-cent road tax on that municipal road. You have to take it out of some other portion of the precinct's budget, road and material budget. So to me, it is flying in the face of what was actually voted on. And I think that we need to be honest with the citizens of Van Zandt County and limit the 10-cent road tax. Despite the city's complaint that we pay this tax and we're not getting anything for it. But we know that these folks that live in these cities do still drive on the county roads. We know that folks in Wills Point or Grand Saline or Canton do drive on county roads. And so we believe that to be truthful with what we voted on back 10 years ago, a little more, is to reserve that 10 cents for these county roads and bridges for their maintenance. And I'm unanimous in that.
All of you, miss?
All of us.
All of you? All of us. All of you? All right. Is there any further discussion? All right. I will now close the workshop as 10:37, and we'll move on to consent agenda. And that consent agenda items are considered routine by Commissioners Court that will be enacted by one motion. No separate discussion of these items unless the county judge or a commissioner requests the item be removed from the consent agenda and considered separately. Are there any items that need to be considered separately? If not, is there a motion to approve the consent agenda?
Motion to approve consent agenda?
Is there a second?
Second.
Motion made and second. All those in favor say aye.
Aye.
All those opposed, like sign. Motion passed.
Adjourn, Mitch. You asked about the jury, the grand jury, so I texted Karen to double check. She did say that we do pull from when we shuffle the jury, and then the judge does go through. So, whatever that.
What do you mean by we do pull, the members selected are selected out of the
jury pool.
jury pool, which is basically registered voters, correct?
And then whatever that is pulled, I believe it sounds like the judge goes through that list.
So
We
the
need to get with Karen Wilson just to double check.
so the judge has unlimited peremptory challenges.
Sure, like I said, I don't do that in there, but I texted her just to double check. I knew that she pulled out of the jury wheel, but what happens after that?
And that would be the district judge that removed it. Yeah.
Well, I want to say one more thing about the workshop.
Go for
The
it.
city of Van came to me and asked me to help them on a project. They didn't ask anybody else, and Van's not mine. And we did, because we always do in precinct 1. We've never had a problem with the city. We've tried to do everything we can to help the city, but I have a responsibility to my precinct. And so I'm not gonna fight with the city. I'll continue to try my best to do what I can, where I can, when I can. But my primary responsibility is to the county roads. That's where I see that falling out. And right now, on the north side of Interstate 20, it is not the same as it is on the south side. The road, condition of the roads. And elections have consequences, and Bobby and I we will not catch it in our first term, and maybe not in our second term. So with that said,
So on the screen is the precinct territories, so you can see they all converge on Canton. So each precinct does have a portion of Canton there.
and there's a lot of people that ask what happened to that $30 million that y'all have collected. And that is a fair question. that we at some point need to answer, be able to answer those questions?
I did an analysis of all the road tax that was collected over the past 10 years. And I think, I don't have it right, I'm doing it from memory, but we spent $10 million more on road and bridge materials than we've collected in road tax.
I know what they're specifically asking is, are y'all just filling potholes with this, or are y'all building new roads? I think that's what they want to know. They want to be able to see what is the bang for the buck. And I believe that we need to be able to give them that information. And we're working on it in my office as far as, at least in my term, collecting that information and being able to put it forth, and they can go drive on what we spent, you know. And I'm also trying to create a criteria of why I choose a road. I've bought some, not a flock camera, but a camera that can tell you the size, speed, and count of how much traffic is on a road, what kind of traffic it is, and I'll be able to give you an idea of how much traffic is on what roads that we're working on, where are the main roads, the feeder roads, and then what it'll cost to build that road, and what I'll spend out of that, 25% of that, 10%, 10 cents tax. I'll be able to give you that information. God willing, I'll be able to give you that information on why we're working, where we're working, because they're all bad. I can throw a dart, shut my eyes and throw a dart over there north of 20, and there's a really, really good chance that you'll find somewhere we need to be working. And I have people say all the time, you're not mowing road ditches. Well, I've got 500, I'm on a rant now. I got 550 something miles and 2 tractors in it mowing.
And you come up with the 550 by
Times
two,
Yeah.
your road
It's
must.
275 times two, you know, somewhere in that area. So those little bitty tractors are somewhere between here and the Gulf, and they're mowing, you know, and it's growing behind them. So anyways, I'm done. Motion to adjourn.
All right. Is there a second?
Second.
All those in favor say aye.
And one other thing.
No. All right, we're adjourned at 10:43.
This process. Everyone's saying